at this stage. He ought to have waited and let the Inec do the referendum to confirm the authenticity or otherwise of the petition. Coming to court at this time is wrong for him. That's what the court has just affirmed and confirmed again. On the issue of fair hearing, that is constituents or those that wanted to recall him must give him or must call him to tell him why they wanted to recall him. The court said no court can do that. You can't come to court and be saying that those that wanted to recall me did not give me fair hearing, they did not call me to tell me why they wanted to recall me. No, you can't do that. You ought to have subjected yourself to the referendum to be conducted by the Inec. If there's any wrongdoing, then you can come to court. But for you not to subject yourself to the referendum and just rush to court to buy for a time, that was not good enough.
We challenged the decision of the trial court on several grounds. One of those grounds was the invalidity of the petition presented to Inec. And at the trial court, we gave Inec notice to produce its petition, which we said was not signed by the maximum number of persons required by the Constitution. The trial court, in its wisdom, without seeing the petition and without Inec producing the said petition, held via the analysis done by Inec that the petition was valid, the basis of which it dismissed the action of the plaintiff. We also challenged the action on the ground that the trial court had no jurisdiction to extend a constitutionally provided time. It has been heard variously in several Court of Appeal and Supreme Court decisions that a time as provided by the Constitution cannot be extended and cannot be elongated by a court of law. So that was also part of the grounds upon which we challenged the decision of the trial court. We also challenged the decision of the trial court on the grounds that loss of confidence in a sitting member of the National Assembly must be hinged on a particular conduct of that sitting member. You cannot just out of the blues come out and say we have lost confidence in a particular member of the National Assembly. There must be grounds upon which, and we stated copiously in our various affidavit evidence that there is no grounds perceivable upon which they could have said that they have lost confidence in our client because of his track record of achievement at the National Assembly. So the Court of Appeal in its wisdom considered these issues. It considered the issue of the invalidity of the petition, and the court held that it was not within the purview of the trial court to determine whether the petition was valid or not. On the issue of extension of a constitutionally provided time, the Court of Appeal interpreted it otherwise. It said that the time provided for the Constitution for doing an act, performing an act by the Constitution, could be extended or elongated. In this instance, the Court of Appeal held that the time as provided for in the Constitution has not started to run, in the sense that the petition is still inchoate. And well, that is not our position, and we hope probably to go upstairs and test these various decisions of the Court of Appeal.